Hi, everyone. Welcome to today's webinar, Board Basics, Board Voting, and Other Board Actions, How to Get It Right. My name is Jason Q. I'm a managing attorney here at the DC Bar Pro Bono Center in our nonprofit and small business legal assistance programs. So, today's webinar is part of our ongoing Board Basics series, which delves into practical, real-world governance issues for nonprofit boards. A few housekeeping matters up top. You can download the slides for today's presentation in your GoToWebinar client. There should be a menu line that reads Handouts. If you click that, you can download the slides from there. The webinar application also allows you to submit questions during the presentation, and I'll make sure to save some time at the end of the presentation for questions. But as we go along, you should feel free to input questions into the question box, and we'll be able to see them on our end. Okay, so a little bit about us at the DC Bar Pro Bono Center. We match nonprofit organizations with pro bono legal counsel. That's our main program. Pro bono attorneys can help nonprofits with many different types of legal matters, including corporate governance, IRS compliance, employment law, real estate matters, the whole gamut. We also host in-person drop-in legal clinics or one-day legal clinics that address specific issues, such as corporate governance, risk management, or intellectual property. We also sponsor trainings, webinars, and podcasts on important real-world legal issues facing nonprofits, like today's event. And we provide written resources and archived training sessions on our website. That's www.lawhelp.org/DC/CED. Highly encourage you to check out that website. It's very browsable. We organize our resources by resource type and by issue area. Okay, so here's a bit of a roadmap for today's webinar. We'll start with a bit of background, talking about the legal duties of nonprofit directors and how that ties into board voting. We're going to talk about how voting works, the rules, the requirements. We're going to talk about alternatives to voting at meetings, and especially the use of unanimous written consent. We'll also talk about whether the board can delegate its decision-making authority to a committee. Spoiler alert, the answer is yes, but we'll talk about how that happens and what the rules around using board committees are. We'll talk about why create committees, who can serve, and what committees can do. So that's a high-level roadmap for what we're going to be talking about today. I should note that the legal requirements we'll be discussing today are drawn from DC law, and in particular, the DC Nonprofit Code. If you are not with a DC nonprofit organization, then your state's nonprofit code may have different requirements. Our laws in DC are modeled after the ABA Model Nonprofit Code. That means there's nothing too crazy or unusual in our laws, but for folks from out of state, you can use this presentation to help understand what some of the issues and pitfalls are related to board voting, and you'd probably want to follow up to make sure that your state approaches these issues in the same way. Okay, so let's start with what it means to be on a board. I want to give some background here because it undergirds a lot of the operational requirements that we'll talk about later. It'll make everything make more sense. And what we should know is that directors are fiduciaries and owe a fiduciary duty to the nonprofit organization. Let's unpack what that means. A fiduciary is someone who is legally required to act on behalf of someone else. Board members of nonprofits are fiduciaries to the nonprofit organization, meaning that you are required to act on behalf of the nonprofit and to safeguard the interests of the nonprofit at all times. The rationale here is that people donate their money to nonprofits with the purpose and intention that the money will be used to pursue a charitable purpose, that the money will be used appropriately, and that the nonprofit will be run in an effective and legally compliant manner. So as a director on the board, you are a key decision maker who ensures that your nonprofit is run effectively. You have a legal duty to do so. And in DC, we actually recognize 4 distinct legal duties of nonprofit directors. There's a duty of care, duty of loyalty, duty of obedience, a duty to inform. We're not going to delve into all of these today, but the most relevant one for our conversation about board voting is the duty of care. And there are some components to this. A director must act in good faith and as a reasonable, prudent person would act under similar circumstances. Director must be informed, use common sense, and be diligent. Directors must act in the honest belief that your actions are in the organization's best interests. Director must review financial records. And finally, a director must attend board meetings and committee meetings. They have to participate and vote. So it's important for the board to be engaged and to have open debate in the lead up to making these decisions. This is all a component of your duty of care. If you do all this, then your decisions as a director and as a board are given a legal presumption of validity. But if you don't, then your decisions can be second guessed, or a third party can come in and wonder why you made the decisions you made. And an important part of that is that the board should create minutes demonstrating its reasoned decision-making process. We did another board basics webinar a few months ago about meeting minutes and the importance of keeping minutes and the best practices around minutes. So if you weren't there for that session, definitely encourage you to go back to our website. It's archived there on the website. I should emphasize here that this duty of care is a non-delegable duty, just like all other fiduciary duties. That means that they belong to you personally as a director. A director can't assign someone else to exercise fiduciary duties for you. You were individually chosen to be a director, and the duty is yours personally. Okay, so that's the backdrop. Let's get into some voting terminology that we'll be using today. So the first one is a quorum. Quorum refers to the number or percentage of board members that need to be present to hold a board meeting and to take effective board actions. Unless your articles or bylaws indicate otherwise, a majority of the board's directors must be present in order to establish a quorum. So if you have a 11-member board, you need 6 directors to establish a quorum. DC law allows organizations to set the quorum at less than 50% in the articles of incorporation or in your bylaws, but they cannot be less than 1/3 of the directors or 2 directors. So there's a floor. Just because you're allowed to set the quorum at less than 50%, it's really not recommended that you do so. Let's say you have a 15-person board. If you had your quorum at 1/3, that would just be 5 people. And of those 5 people, 3 people would carry a majority vote. So you would have 3 people carrying votes on a 15-person board. That wouldn't be a great situation. It would make it very difficult for the board members to really exercise their fiduciary duties. So, that's why we recommend that you still go with the higher threshold. If a quorum is not present, the board can still meet and can still discuss issues, but they cannot take any board action with respect to any matters. So you can still discuss, you can receive information, have conversations, but you can't take binding votes at a meeting without a quorum. Because of this, attendance matters, and a common provision that you'll see in nonprofit bylaws is that if a director has more than 2 or 3 unexcused absences in a year, they're automatically off the board. This is a provision that you might want to consider if you don't already have it in your bylaws. The good thing is that it's automatic. You don't have to have a vote. That means that there's no bad guy, there's no heavy that has to deliver the bad news that someone's going to have to get kicked off the board for poor attendance. It just happens by way of the bylaws. And it also communicates to board members, especially new board members, that attendance is important. So especially if you're going to be setting, a high quorum threshold, if you're finding that you're having trouble meeting your quorum, you can think about ways to improve board attendance, and this bylaw provision requiring attendance is one way to do it. So let's talk about voting. Majority vote. A majority vote is a vote by more than 50% of the directors present at a meeting. So unless the nonprofit code, articles of incorporation, or bylaws provide for require a greater vote for something, most votes can be taken by a majority of directors present at a meeting. This is in contrast to an absolute majority vote, which is a vote by more than 50% of all the directors on the board, not just those present at a particular meeting. So a common example is that bylaws will often require an absolute majority for the election of directors and officers. And we'll talk about other situations when you would want an absolute majority vote versus a majority vote for your meetings. So for example, if there are 11 directors in total and 9 are present at a meeting, a quorum is present, but the board can only elect an officer or director if 6 directors vote yes. So that's an absolute majority. 5 votes would be sufficient for a majority vote at this meeting, because 5 would be, more than 50% of the 9 people present, but it wouldn't be enough for an absolute majority. So there's the difference. I also wanted to make one note about ex officio board members. So ex officio directors are members of the board by virtue of their office. So your articles or your bylaws can say that the executive director is automatically a member of the board. A common misconception is that ex officio members are by default non-voting members, and this is not the case. Directors have voting powers by default under the nonprofit code. If you want your ex officio members to be non-voting members, the bylaws should explicitly state that fact. As a general matter, we don't recommend that you have non-voting members on your board. If you do, these individuals have the fiduciary responsibilities. They're expected to show up at meetings, but because they don't vote, they don't have any control over the actions that the board ultimately takes. So they have all the liability and all the responsibility, but they don't get to influence the direction of the board's decision-making process. It's kind of a lose-lose for them. That's why we don't recommend non-voting members of your board. Okay, so here's one big mechanical question. Do you have to be physically present to vote? The answer is no, not really. Directors do have to be present at meetings to vote on matters before the board. But unless your bylaws provide otherwise, you can be considered present at a meeting even if you're not physically at the meeting place. And you can do this by participating electronically. So some bylaws explicitly will allow telemeeting, teleconferencing, or electronic meetings. Even if your bylaws don't explicitly allow this, it's allowed under the DC Nonprofit Code. It's probably a best practice to write it into your bylaws that you can meet electronically, just so that it's clear to the directors and to the folks reviewing your bylaws that this is a valid way that you can meet. Electronic presence at the meeting requires that the director be able to hear all the other directors at the same time, that the director is able to participate in the meeting, so they have to be able to speak, ask questions, provide input, and vote. And this can be achieved through a conference call or a video conference or Skype or some other platform like that. Okay, there's another question. Can you send an alternate or a proxy to vote? Because directors must be present at the meeting, you cannot use proxies. You cannot send an alternate to vote in their place. You can't send your vote in advance by email or by paper ballot. I've seen a lot of bylaws that allow proxy voting on the board, and under the DC code, that is not allowed. So if that's in your bylaws, think about taking it out. Board members may not delegate to anyone else their responsibility to attend meetings or to vote on matters before the board, including other directors. And only individuals can serve on a board. A nonprofit cannot have an institutional seat, and a director cannot send someone else from his or her organization to a meeting in their stead. And this is all derived from the idea that we talked about earlier, that your duties as a director are non-delegable, that they belong to you as an individual. It's also connected to the idea that you need to exercise your duty of care when you're voting. And so that includes listening to the viewpoints and to any new information that can arise during a meeting. If you send your vote in by advance, you're voting without the benefit of that additional information. So that's the idea here, with the prohibition on proxies or alternates. Okay, but there are other ways to take board action. When an organization cannot take board action at a full board meeting, it can still act using unanimous written consent or through board committees. And so let's talk about both of these options. Acting by unanimous written consent. Okay, so instead of holding a board meeting, a board can vote on an issue by unanimous written consent. This consent must be in writing. It must state with specificity the action being taken. It must be signed by every director on the board. So if there are 9 directors on the board, the consent must be signed by all 9. It's not sufficient if 7 sign and 2 just don't respond. Unanimous means unanimous by everyone. And finally, it should clearly state that a vote is being taken by written consent and that the vote must be unanimous to pass. The idea here is that people need to have notice about what they're getting into. Let's say you have a 9-person board and you're voting by written consent, and folks don't know that the vote has to be unanimous to pass. If 7 people vote yes, the remaining 2 people might just go along with the vote because they're like, oh, well, it's 7 out of 9, we've already lost. We might just follow the majority and vote yes. If they knew that the vote had to be unanimous and they could essentially veto the decision, they might vote differently. They have a lot more power. And that's by design, because the idea of voting by unanimous written consent is that the underlying issue is so non-controversial that there's no point in having a meeting. The point of a meeting is for people to hash issues out and for people to air conflicting viewpoints. If you can get a totally unanimous vote up front, then it's less important to have a meeting to really discuss the issue. But if even one director dissents, that director has a right to bring their concerns up at a meeting, and you can't act through written consent. So electronic signatures are acceptable in DC for the purposes of these unanimous written consents. You can do this over email. You can do this electronically. But the signature on a director's written consent must be identifiable to a specific individual and must be tied to a specific action. So for example, here's an acceptable written consent. It's from jq@dcbar.org. I consent to the proposed action set forth in this email. And maybe a copy of the resolution is attached, or maybe in the email thread, the full description of the resolution is there. And then it has my full name. This is just my standard email signature block and my contact information. So anyone can understand from this consent who the specific individual is that's giving the consent and what the specific action is that they're voting on. In contrast, this wouldn't be acceptable if, Susan, our board president, sent out a resolution and I emailed her back, "Hi, Susan, that's fine by me, Jason." And the email address is jcool@gmail.com. Someone looking at this from the outside can't be sure which Jason this is, and it's not clear what issue we're talking about. So that's an example of an email consent that wouldn't be formal enough for the purposes of a unanimous written consent. These examples are email signatures. A more conservative or formal approach, but that's probably better for record keeping, is to send everyone a signature page that they can sign and then send back. You might require people to print it out, attach a cursive signature, scan it, and then send it back. That would be the most formal way of doing it. A middle ground might be to create a signature page that you can e-sign through like Adobe Acrobat or some kind of software like that, and then you can email that back. So all of these approaches are fine. You can do it using cursive signatures. You can do it using email signatures. That's up to you and your organization. A record of the unanimous consent must be kept and should be stored with the minutes of the organization. So keep it in your minute book, treat them as you would other minutes. And you should include copies of all the responses from the directors. So if people are responding via email, include a copy of all the email threads with the directors indicating their consent. This is where it might be beneficial to require the signature page. That way the secretary or whoever's compiling the minutes can take all the signature pages, kind of staple them together or put them in one file, and then you have everything in one place. So if your organization has been voting outside of meetings but has not been requiring unanimous votes, that's an issue because the validity of those votes could be called into question. The good news is that you can go back and you can ratify those decisions. The board always has the power to ratify previous actions of the board. So have a meeting, look at the issues that you voted on virtually, And you can ratify any decisions just so you have that extra layer of protection and make sure that those issues are properly approved. So your bylaws don't have to explicitly allow actions by unanimous written consent. The DC code itself allows you to do it. But again, it's a good practice to write it in. It just makes it clear for all the directors that this is a valid way for the nonprofit to make decisions. And it can also make it clear that it's a unanimous requirement. It's another place to put that requirement. Okay, so that's written consent. Let's talk about actions taken by board committees. The DC Nonprofit Code provides for two types of committees. You have board committees, which are composed only of directors. The board may delegate some of its financial duties to a board committee. So some examples are a finance, audit, compliance committee, or a compensation committee. Another very common one that we'll talk about are executive committees. Board committees can vote and they can take action on specific issues within their subject area. And the second type of committee is advisory committees. Advisory committees can be composed of non-directors, but they do not have the authority to act on behalf of the board. They can take non-board actions, so those are actions that could otherwise be delegated to staff, or they can issue non-binding advisory opinions to the board. So you might have a fundraising committee, special event committee, public relations committee. You have a lot of different kinds of advisory committees. So why would you want to create committees? Well, board committees are useful because they can help divide the board's work amongst the directors into more manageable amounts. They can decrease the amount of issues that come before the full board. They can help directors with special expertise concentrate on the subject matter that they know most about and to which they can contribute the most. Advisory committees can help the board and staff manage their workload as well. They can bring outside expertise to the board. They can encourage donor, member, and volunteer participation. It's a great way to get your donors involved more formally with the organization. And it's a useful tool for recruiting and test driving new board members. If they're showing up and contributing to an advisory committee, that's a good sign that they can also contribute to your board committees or to the board as a whole. So how do you create a board committee? Your bylaws should empower the board to create committees as needed. Go take a look at your bylaws. Most will have a section on committees, and they should empower the board to create committees as required. The creation of each committee has to be approved by an absolute majority of the board, not just a majority of those present at a board meeting. The resolution creating committee should also specify the duties and authority of the committee, the number of directors, and the composition of the board. For example, you'll commonly see a finance committee resolution saying that the treasurer is automatically a member of the finance committee. That makes sense. An absolute majority must also approve which directors are appointed to the committee. So you see that we have an absolute majority requirement to both create the committee and to appoint the individual directors. The idea here is that the whole board is delegating its power to a subset of the directors. That's a lot of trust. That's a lot of responsibility. So we want to make sure that we have a board level approval of these decisions, of that delegation, not just a majority of whatever quorum happened to show up at a particular meeting. I should note that board committees can also be created within the bylaws themselves. You'll often see the bylaws creating an executive committee, for example, and providing information about how that committee operates. You would still need, in some cases, a board resolution to flesh out certain operational details. But the more common approach nowadays is to see the bylaws just giving the board the authority to create committees on demand. It's more flexible that way. And then if you want to create or dissolve or change a committee, you don't have to go into the bylaws and make those changes. You can do that at the board level. You can just amend the resolution that created the committee. So it's a more flexible approach. Going back to that issue about requiring an absolute majority, a lot of nonprofits will have the chair nominate individuals to serve on a committee. That's fine, but you still need the board to approve or finalize the nomination. So you can't have your board chair unilaterally appointing people to your board committees. And again, these are board committees. These are committees with the authority to act on behalf of the board. So what can board committees do? Board committees can take any action that would otherwise require board approval. They can exercise the same authority as the board in their subject area. For example, a finance committee can have the authority to approve changes to the budget without requiring further board action. Some other examples, the board can delegate the responsibility of selecting independent auditors. They can have a committee approve the CEO's compensation. They have a committee approve changes to the budget. They can have a committee that appoints investment advisors. These are all common functions of board committees. And the key here is that the committee has the authority to act on behalf of the board. In practice, the committee might always just do things on an advisory level. They might recommend who the auditor should be, but then still leave it to the full board to approve their selection of the auditor. But if they have the authority to make that final decision, we're going to treat them as a board committee, and we're going to, for example, only allow board members to be on that committee. Some duties cannot be delegated to board committees and under the DC Nonprofit Code. So these include the right to authorize the distribution of the organization's assets, the authority to adopt, amend, or repeal the Articles of Incorporation or the bylaws, the ability to fill vacancies on the board or any board committees. Dissolving the organization cannot be done by a committee. And in the case of a membership organization, a committee can't propose any action to the membership that requires the members' approval. So let's talk about executive committees for a minute. An executive committee is a committee of the board which is given the authority to make any decision that the whole board could otherwise make, subject to the exceptions that we just discussed above. The bylaws or the authorizing resolution can also carve out additional exceptions, like maybe you don't want the executive committee to have the power to hire or fire the CEO. The bylaws or the authorizing resolution can also limit the committee's authority to overturn a board decision, or they may require the board to ratify certain decisions made by the executive committee. So there are different strategies you can use to cabin the powers of the executive committee, which are otherwise quite broad. Executive committees have traditionally served 5 main purposes. The first is that the board may not meet very often. Maybe you have a big board, maybe board members are spread out, across different time zones across the world. And convening a special meeting of the full board may be logistically difficult. So your executive committee can allow the board to make routine decisions between your regular board meetings. A second function is that the members of the executive committee are typically people in leadership positions or they're officers of the organization, so they may be more informed and can make decisions more easily than the full board. So it's a more streamlined, more efficient way to make certain decisions. The executive committee can convene and make decisions more quickly in times of crisis. It's a related thought. And by handling the routine matters, the executive committee can free up time for the full board to handle more important or more strategic matters. And finally, the executive committee can serve as a sounding board for senior management in a way that a larger group of directors cannot. So these are some of the rationales that people have for using an executive committee. But there are mixed opinions about whether a nonprofit board should have an executive committee. So some concerns that we hear about executive committees include that the executive committee may become cliquish or secretive and exclude other directors from decision making. The board may become disengaged and take a back seat. So then you get a board that's not meeting its fiduciary duties, but that still risks exposing all the directors to liability for actions taken by the executive committee. By establishing an executive committee, the board really might be failing to address more systemic problems like board attendance. So if you're having a hard time meeting a quorum at the full board, it's a band-aid solution to just have all those decisions being made at the executive committee level. You should really go back and look at the underlying issues that are causing the problems with board attendance. And also the availability of teleconferencing, and as we talked earlier, unanimous written consent that you can do via email. It makes it easier to take actions using the full board. So technology is also having an effect on the efficiency of boards and the ability to use a full board versus your executive committee. Okay, so those are board committees. Let's switch over And let's talk about advisory committees. The board can also create advisory committees. These are committees that do not have any of the board's powers and responsibilities and only serve as advisors to the directors. The board must subsequently approve any of the advisory committee's policy recommendations. Advisory committees can also perform other non-board functions that could otherwise be handled by staff. Non-directors, volunteers, or individuals outside of the organization, as well as directors, may serve on the advisory committees. They're a good way to help encourage the involvement of donors, community members, and outside experts. So, a good example of something an advisory committee might do is you might have a special event, and you can create an advisory committee once that event has been authorized by the full board to handle sort of the logistics of that event, selecting the caterer, selecting a venue, things like that. So advisory committees can take some actions, but they can't make binding board decisions. So we want to make that clear here and have that contrast. Let's talk about the relationship between your committees and your full board. So directors must still oversee the work and actions of your committees. Board committees are required to take minutes, and those minutes should be distributed and reviewed by the board. Directors may rely on the information or recommendations of a committee if it's reasonable to do so. So the idea here is that they're composed of directors, they've been authorized to make certain decisions or to do a certain scope of work. The full board doesn't have to recreate their work. They can rely on the work of their committees. But the key word here is reasonable. So the board should not, for example, rely on the financial information provided by their finance committee if it knows that the committee never met or never reviewed the organization's financial information. So if there are any signals that the committee is not operating in a way that's diligent and that they're meeting and discussing issues, then it wouldn't be reasonable to rely on the committee's recommendations or information. The board must step in these cases if a committee fails to act in a prudent and diligent manner. But outside of that, the board and the committees, they can work together, and the full board can rely on the information provided by the committee. So that's the end of of the presentation. We're going to move over to questions. So just to summarize, kind of at a high level, board voting, the default understanding is that votes are taken at board meetings at which a quorum is present and at which proper notice has been given. We haven't talked about notice in this presentation, but we have another Board Basics webinar about notice requirements. So that's something else to go back and take a look at. But if you can't get a meeting together, you can vote by unanimous consent. You can vote through your board committees. Those are other good options as well. Let's see what our questions are. Give me a minute to run through these. Okay. Can you speak to creating informal working or task groups on a short-term basis to do specific tasks like drafting a policy and then goes to the board for a whole vote? So that's exactly what we were just talking about a minute ago. That would be an advisory committee. The board should be able to create advisory committees on demand. Again, check your bylaws to see the board's ability to do so. If that's not in there, that might be something you want to address, something to change in your bylaws. The creation of advisory committees is less formal than the creation of board committees. Because you're not delegating out fiduciary duties, you don't need those absolute majority vote requirements. So you can create an advisory committee more easily than you can create a board committee. Something else to also flag. Do you have any examples for policy advocacy groups as to what types of decisions should be approved by the full board and what type of work the policy advisory committee could do? So, first we have to talk about whether this policy and advocacy, okay, so we're talking about advisory committees. Well, advisory committees, you can give them a broad scope of tasks because at the end of the day, everything's going to be approved by the board. At the end of the day, everything's going to be non-binding. It's going to be advisory. So you can give them, a lot of duties. You can have them draft reports. You can have them making some decisions about what issues to focus on, because at the end of the day, the board is going to be reviewing any final decisions that come out of that. I think the most important thing that you want to think about with your board's fiduciary duties is really making those big strategic decisions for the board, and also decisions that relate to the assets of the organization. So decisions around spending money, about making investments, those are all decisions that have to be made on the board level, and are not issues that should be kind of hammered out at the advisory committee level, even on an advisory basis. You sort of want the board to be the body that's going through that deliberative process, because, again, that's your fiduciary duty as the board. So that's sort of the realm of issues that shouldn't be delegated to an advisory committee. Okay, let's see here. So one question, is the executive director typically a member of the board? Typically, that's hard to say. Executive directors are very often members of the board. We mentioned ex officio members up top. So in some organizations, the executive director is, per the bylaws, automatically a member of the board. The executive director does not have to be a member of the board. And there is a strain of thought, or in certain organizations, it might be most appropriate for the executive director to not be a member of the board. The concern here is that the executive director, as an officer and a staff person, will often have conflicts with certain decisions that the board is making. For example, the executive director should not be voting or deliberating on their own compensation. Executive directors are also typically conflicted out of appointing new members to the board, because the idea is that the board is their boss, so you shouldn't be picking who your boss is. So having the executive director on the board can lead to a lot of conflicts, but those conflicts can be managed. Organizations should have a conflict of interest policy. That's another webinar that we have available about conflict of interest policies, and we have written guidance on those. So if you have a robust conflict of interest policy, if you're good about managing your conflicts, it's more likely that you can have your ED on the board and not run into serious conflict issues. You'll know when to ask the ED to leave the room and to make a decision with the rest of the board. So yeah, it's permissible to have the ED on the board, and a lot of organizations do it. So a bit unclear on non-board members being part of a board committee. It seems common to have someone's financial expertise serve who may not have full time to be on the full board. So if it's a board committee that has the power to make final decisions around, approving budget amendments or selecting an auditor, the only voting members on that board, have to be the directors. Now, you can have guests or advisors or consultants on a committee, so that might be a good opportunity to bring someone in with some financial expertise who doesn't have time to serve on the full board, to come in and to consult and to talk through issues. But those people cannot be voting members. So that's the distinction here. If you're having votes, only board members. It's kind of a simpler way of putting the rule. Can you please elaborate a little bit on the board duty of information? So I don't think we have time today to go too deep into fiduciary duties, but I will say there is a duty to inform in DC. That's a fourth fiduciary duty that's not recognized in every other jurisdiction. The duty to inform is essentially a duty to share information that's relevant to the organization with other board members and with other key stakeholders. If you have pertinent information for the organization, it's sort of an extension of your duty of care. It'd be a little reckless. You wouldn't have the organization's best interest at heart if you weren't sharing that information openly with the other board members. So I think that's what we're talking about here with the duty of information. Is this webinar audio available to those who had to join late? Yes, I'm sorry, I should have mentioned that. This webinar is being recorded, and we'll have it uploaded in the next day or so, along with a copy of the slides. And for those who joined late, you can download a copy of the slides through your GoToWebinar client by clicking on the Handout tab. Can you talk more about what types of decisions should be voted on? I sometimes see boards get bogged down with voting on everything, like next steps on the nomination process or the draft questions for the nomination process. Okay, yeah. So there's no one-size-fits-all answer to this because organizations, come in different sizes and flavors. Sometimes you'll have a very active board that is involved pretty intimately with the management of your organization. You might not have a lot of staff, or there might be no staff. It might be a volunteer organization and the board is making all the decisions. At that level, it makes sense for the board to be very involved. But then on the other side of the spectrum, you'll have boards that are performing an important oversight function, especially on those financial and strategic matters, but that's less involved in the day-to-day management of the organization. They've delegated that to staff. So then in those cases, you'd want the board to be less involved on those day-to-day decisions. You can still have them be involved in day-to-day decisions, but as a structural matter, they might not have to be. And again, this also goes to the idea of board committees and executive committees. We talked about that being a benefit of having an executive committee that handles maybe the more routine or kind of, what should be on a form. That kind of thing could be something that's handled by an executive committee that you wouldn't want to, bat around at a board meeting with your full 15-person board, taking up a lot of time. But as I mentioned earlier, decisions relating to the assets of the organization, the financial management, and reviewing financial records, selecting auditors, that's an extremely important function of the board, and that should be definitely done at the board level. What information will be uploaded at lawhelp.org? So I have here on the final slide a link to our website, lawhelp.org. This webinar will go on the website along with the slides. And I have a link there on the bottom to our Serving on the Board of Directors collection. That is a collection of all of our board basics resources. It has a great guidebook called Welcome to the Board of Directors that's designed to provide new board members, but also existing board members with a survey of their fiduciary duties and a description of what their job is and what their duties are. We have a great resource on there called A Year in the Life of a Nonprofit Board that spells out the life cycle of a year in the board and sort of provides a good list of sort of decisions and tasks that the board can take throughout a year. So I would highly suggest that you check out that kind of smaller, more specific link there and see the resources that we have there. We also sponsor a recurring boot camp for nonprofit directors in partnership with the Center for Nonprofit Advancement. Our next one is coming up at the end of September. This is a day-long Saturday boot camp where directors can come in and we run through a lot of key issues like financial management. We'll talk about these fiduciary duties. And so that's also a really great event. The more information can be found on our website. So go to lawhelp.org/DC/CED and we have a nonprofit event calendar. And you'll see that event there. That's the boot camp for nonprofit directors. Okay, so with that, unless people have any other questions, if anything occurs to you at a later time, my email is here, and you can email out and we can discuss these issues. Great, thank you everyone for attending. Have a great rest of your day.